My name is Jessica Saxon. I'm a civil rights advocate and litigator from Washington, D.C. I'm here to provide public notice. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution for the United States is the overarching requirement that every state must follow. I don't think anyone here would disagree with that. States cannot enact their own alternative legislation and substitute that for the guarantees of the Constitution. That would mean that your state laws would be more powerful than the Constitution, and that's simply illegal. Clause 1 of Amendment 5 to the United States Constitution says that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. However, the state of New York has enacted in its alternative legislation a law that permits prosecuting attorneys and police officers to charge by way of information as opposed to indictment. That is unlawful. I'd also like to draw your attention to Roberts versus United States. 1984, this was a landmark decision where the Supreme Court held that the intimate association between that of a parent and a child is a fundamental liberty that is protected by the First and the 14th Amendment. There is no greater form of assembly than that of a parent and a child, and when the state issues a policy or a law or financial incentive to forcibly separate children from their parents without evidence of due process and without clear and convincing justification, that is a violation of the rights that are secured and protected by the United States Constitution. Bringing this back to your local legislation and regarding the Fifth Amendment, Clause 1, and then what I just mentioned regarding the First and the 14th Amendment, an emolument violation is when you pay a public official to commit a crime. There are two areas of the Constitution that reinforces this. So Article 1, Section 10, says that no state shall create any law that shall impair the obligation of contracts. Police officers, prosecutors, and judges are all under a contract. That's a contract to perform based on the oath or affirmation that they took to support and defend the Constitution of the United States. So when a state enacts a law and then directs their agents to disobey that law, that is a violation of Article 1, Section 10. The 14th Amendment is the other place that you find the reinforcement of this issue. And that's where it says that no state shall create or enforce any law that shall abridge the privileges or immunities of the United States citizens. Privileges and immunities of United States citizens are at a minimum those that are enumerated within the Bill of Rights and the first 10 amendments. So when the state of New York enacts a law in its inferior constitution that permits public officials and law enforcement officers, whom you all pay, to violate the Constitution of the United States, that is an emolument violation. It is illegal. To add to these injuries in paying your local law enforcement judges, prosecutors to either interfere with unlawful arrest or interfere with parental rights, these actions are also incentivized locally by federal funding programs like Title 4D and Title 4E, which offer money in exchange for custody transfers, child support orders, foster care, keeping cases open in juvenile court under dependency and neglect. All of these things is an emolument violation. Mr. Tanoa Downing is preparing to litigate this issue at the United States Supreme Court on behalf of more than 700,000 people currently incarcerated unlawfully here in America, as well as the families and the children that our government is unlawfully removing from the care and custody of their parents. I'm here today to notify you that you cannot continue to pay public officials to break the law. If a law enforcement officer goes out and assists in removing a child from a parent because of an unlawful void order of a judge, that is a violation. Paying people to disobey the law and commit crimes against us, it is illegal, it is unconstitutional, and it is a crime. So I'm asking you, honorable individuals, to please take a look at Clause 1, Amendment 5. Take a look at the First Amendment, the 14th Amendment, as well as Roberts versus United States JCs, that was incorporated in 1984. Confirm what I'm saying to be true, and then direct your public officials, your law enforcement officers, your prosecuting attorneys, and your judges to act in a lawful, constitutional manner consistent with the obligations codified in the United States Constitution. And I do have a notice that I would like to put on the record, please. Thank you so much.
Thank you. The clerk, please call the next speaker.
Tanoa Downing.
Good evening. My name is Tanoa Downing. I'm the civil rights litigator that Ms. Saxon was just talking about. I want to step up and provide just a little bit of clarification so we can understand what was just said.
State your name and your location for the record, sir.
I'm from Washington, D.C., civil rights litigator from Washington, D.C. Thank you, sir. Again, I just want to provide some clarification because I know that some of the things I just said might be a little bit foreign. I have approximately 56,000 criminal affidavits on behalf of victims that have been charged by way of information, not by indictment, from right here in the state of New York. These are per se crimes, which means that I don't have to prove that those public officials intended to breach their constitutional obligation. Simply by virtue of the breach, all elements of the crime have been met. because their willfulness and their knowledge derives from promise they make. When you make a promise that you will fulfill your obligations codified in the Constitution, you must do so. Now, these affidavits, again, no state can create a law in its inferior constitution and substitute it for the guarantees of the Constitution. That would be an unconstitutional law. So when your law enforcement go out and they perform an arrest and they charge by way of information, because that's the way they were trained to do it, because they're relying upon an inferior state statute, despite the fact that the Constitution of the United States says that no person can be held to answer for a capital or rape crime unless on presentment or indictment of a grand jury, that officer just committed a crime. It's called deprivation of rights under color of law. It's Title 18, subsection 242. What that statute says, it says that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. Now, these affidavits identify a second crime, and that's Title 18, subsection 241, which is conspiracy to deprive of rights. What that statute says is that when two or more persons conspire for the purpose of depriving any person of any right secured by the Constitution, commits that crime. Now, the laws of criminal conspiracy for public officials, they state that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined to dispense the action. So upon providing this notice to all of you and letting you know that the law enforcement here in the state of New York, your Albany police officers whom you pay are going out and they're performing unconstitutional arrests, I would ask you guys to let's please step up and let's stop that. You can stop it in a couple of different ways. One is you stop paying them to commit a crime. Or number two, you work with them and direct them to act in a lawful constitutional manner consistent with the obligations that they have codified in the Constitution of the United States. That's what your legislative body has the power to do here. Now, I understand that it's the mayor that directs agencies and departments, but you guys hold the budget. So I'm going to ask you guys to please, let's work together and let's fix this problem. So the alternative is that we would have to start converting these criminal affidavits into criminal complaints. I don't want to go down that path. You guys don't want me to go down that path. But we have spoken with the director of the FBI, Mr. Patel. We've also talked with the Senate ranking member, Senator Kennedy, of the Senate Judicial Oversight Committee, and they both agree that when public officials, including judges, police officers, and prosecutors, when they choose to abridge the obligations they have codified by the Constitution and fail to obey federal law, they are subject to arrest. Again, we don't want to go down that path. So what we're here today is we're here to inform you of a situation so that we can work together to fix this problem. Because the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. That proceeding is there to protect the individual from the prosecutor, and yet it's the prosecutor in your law here in the state of New York that is deciding whether or not they get that protection. That is not a proceeding that's there for any benefit but the accused to be protected from an overzealous prosecutor. So I'm not saying that these are good people. I'm not saying that these are lawful people, but what I'm saying is that these are all rightful people who all have rights that have clearly been abridged by the state of New York by agents that you pay. And so there's a much better way to treat our people than to arrest them and put them into involuntary servitude in a for-profit business for the direct benefit of the state. And that's what we're getting ready to argue at the United States Supreme Court. Now, I know that you guys are going to go and you're going to ask the attorney whether or not what I'm saying is true. And that attorney is going to say to you, well, not really. And they're going to point you to a case from 1884 from the United States Supreme Court called Hurtado versus California. And before you choose to rely upon that as the foundation, I want to remind every single one of you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution because that must be done by an authentic act of the people in accordance with the special amending procedure of Article 5. Furthermore, the judicial branch has no authority to legislate. Judges cannot do that. That's codified in Article 1, Clause 1, where it says all legislative powers vested in Congress of the United States. So I implore you, please step up, discharge the duties
Thank you, sir. The time is up.
fulfill the obligations promised to the people of the United States, and let's support the